Please be advised that this podcast was made for fun and to share the general experiences of two criminal lawyers in Toronto. You must not take anything you hear in this episode as legal advice. Every situation for every person is different, and you should always consult with a lawyer for legal advice specific to you and your circumstances.
Welcome to Titan LLP's or Titan Defence LLP's first inaugural podcast, Justice Redefined. We're your hosts, Kabir Sharma, criminal defense lawyer and partner at Titan Defence LLP, and I'm joined by
Sina Shabestary, partner, criminal defense lawyer at Titan Defence LLP.
And our first guest for this podcast is the only person who we could force to come out at 9 o'clock in the morning on a Saturday, and that's the person we pay. That's our employee. Kayvan Vakili, introduce yourself, man.
That's right. It was 8:30 in the morning, and
nobody else is here.
That's right.
And I'm not getting paid. So let's clarify things. No, I'm joking. I'm very, very happy to be here and talk with you guys.
So, what's this podcast about, Kabir?
I think that there's this real issue where like lawyers or what lawyers do and think about is like secret and hidden, and it's not something that the general public really knows about. People don't really know about how lawyers discuss cases, come to conclusions, the steps they take, why they take those steps. And the law is basically one of those things that's so complicated that you have to go to school for 10 years to even understand how it works, but yet it affects everybody's life. And I think this podcast is kind of meant to shed some light or to simplify the complicated and complex aspects of the law so that, you know, the average person can understand it and maybe even enjoy it. So I think that's like the purpose of this podcast.
I think obviously our opinion may be biased, but I find the criminal justice system to be fairly interesting. And so why not simplify that for the masses?
I agree. And, you know, it's funny you said we go to school for so long just to understand the law. And I could say that even after all that schooling, it's still so complex to navigate. And, you know, there's a lot of on-the-job learning as well. So, you know, I can only imagine what it's like for people who don't have any of that background and who try to navigate those waters on their own. So hopefully this podcast could shed some light for everyone out there.
All right. But before we get into the nitty gritty, I think it's important that we make it clear that none of what we're about to get into is legal advice, and it shouldn't be taken as legal advice. We're just a few dudes talking shit about the criminal justice system.
Yeah, please don't listen to this and say, oh, the Titan LLP people told me to do these, you know, possibly stupid things that we're going to be talking about. You know, if you want actual legal advice, come pay us and then we'll give that to you. But not here.
All right. So our first episode, as Kabir has already stated, is with our associate Kayvan Vakili. He's sort of our guest speaker today. And what we're going to be covering in today's episode is effectively the process. What's the process in the criminal justice system for an individual who's charged? And we'll hope to simplify that as much as possible. So first and foremost, Kabir, I think let's start with under investigation. What does under investigation mean?
So we'll start. We'll start with under investigation. I think the best way to kind of, explain the process is to kind of use an example of, something that's in the news of some kind of a criminal act. And I happened to come upon this absolutely hilarious article of somebody who, I don't know, may even be my hero of some kind. And I'll read the article out, and I'm sure some of you guys may have read this on Instagram or heard about it. But so this is what the article says. It's from Monroe, Louisiana. A Louisiana man has been accused of slapping a police officer unprovoked. A Monroe police officer said that he was driving by when Troy Davis waved him down on October 24th. The officer wrote in an arrest report that Davis approached the driver's side window of his car and said, "What up, man?" and then slapped the officer in the face. According to the report, Davis then said, "Fuck the police," as he began walking away. Davis was then promptly arrested and booked for a felony charge of battery of a police officer. I think one thing the officer didn't include in his report is how he probably beat that guy's ass. That's something that's not included, but we'll get to that. So I think we'll kind of use that as an example case to kind of explain what the process would be like in Canada. So under investigation, well, this person wasn't actually...
Straight to arrest.
This person wasn't ever under investigation, but what people don't know is even after you've been charged, the police are still conducting an investigation. So just because they've arrested you, it doesn't mean that their investigation stops. In some cases, the police need to do an investigation to, for example, figure out who committed a crime. That's one type of investigation. You know, if someone leaves DNA somewhere, if someone breaks into a house, they got to kind of figure out who that person is. In other cases, it's not so much they figure out who the person is, it's how can we prove that this actually happened, right? So what the police officer will do, maybe the investigation will, for like this gentleman, Mr. Davis, the cop is probably looking up this guy's criminal record and see how many cops he slapped in the past, perhaps, or, you know, any other kind of things that he's done that kind of demonstrates that he has a propensity to, like, you know, do these kind of stupid things. And that's basically how, you know, this particular investigation took place. But at the same time, when you're under investigation, it's always wise to consult with a lawyer, because a lawyer can even help you at a stage when you're being investigated. Like a lawyer can communicate with the cops, convey to the cops, you know, any statements that you wish to give or anything like that. So, you know, lawyers are often hired by people who are under investigation,
right,
as well.
And I think in this instance, it's, you know, safe to say that as soon as you commit an offense as against the police officer directly, you're not under investigation. you're under arrest immediately. So I think to make that fit a little bit, let's say Mr. Davis had slapped a civilian, and then police were called on scene to presumably investigate the assault. Then what they would start to do is take statements from everyone, say what's going on, and that's the investigation process before they say, okay, are there enough grounds here to lay a charge and to arrest the individual? So, Kayvan, what does the arrest then entail?
Well, first and foremost, the police have to have reasonable and probable grounds.
What does that mean?
What does that mean?
Right.
Yeah.
So there has to be something which it has reasonably arisen this suspicion of the police officer. And the word reasonable here is where the emphasis is on, because, you know, if you're just standing outside with your hoodie up and you look suspicious, that's not reasonable, okay? If a police officer sees a hand-to-hand transaction that you've taken part of once you've come out of a known crack house, that could be reasonable. So the word reasonable is very important. But once that threshold, and it's not a very significant threshold, as it would be, for example, once you're at trial. But once that threshold is met, you could be detained and you could be arrested based on what the police end up finding.
And it's actually pretty crazy, because I get this question all the time. People often think that the police, in order to arrest somebody, need some kind of concrete evidence. They need evidence of injuries, or they need evidence of DNA or something like that. But what people don't understand is someone's word is not only enough to get you arrested, but also to get you convicted of the offense. So for example, if you get into a tussle with your wife and girlfriend, and for example, you say that she's lying about it, and I often hear, oh my God, she just said this to the police that haven't even confirmed everything. Well, listen, if she's believed in court at the end of the day that this happened, that's enough to convict you. So they don't need more than, someone's word, which is reasonable probable grounds to arrest someone, which happens all the time in for example, domestic assault situations.
Yeah, and that's an important point. It's a question that we often get, which is someone's word is enough. And why is that? This person's lying, they have it out for me, et cetera, et cetera. And what I say at that time is that this is not the time for it. It's not relevant at this stage, because at the end of the day, making the assertion is almost always enough. And the time for credibility as to see whether there's a motive to lie or whatever the case may be, that's for trial. And unfortunately, that's the way the system is structured, perhaps unfortunately or fortunately. The bottom line is, especially in an example like that in a domestic scenario, because of a liability issue, as soon as the police are called on scene, they will investigate. And for the most part, they're going to lay the charge unless it's something that's utterly absurd and it's just not believable, because they don't want to have that liability on their hands either.
Yeah, why didn't you charge this guy?
Right. Well, the
right?
police,
like that's what they're gonna hear, and they don't want to avoid that.
In some instances, I would imagine the police rock up to a domestic incident and think to themselves, "This is ridiculous. Why are we even here?" But they'll still end up laying the charge in some instances, because if they leave and lo and behold there is an assault or something does happen to one of the parties, then what are people going to do? They're going to point the finger at the police. They're going to say, "You were there. You could have prevented this from happening, and you didn't."
And I think, one interesting thing about domestic is that I get this often with my domestic clients, where they really they minimize the situation. It's like, oh my God, how could this even happen? Like, nothing happened between us. It wasn't a big deal, so on and so forth. But, I think so often back in the day that these cases were sort of handled and swept under the rug, or they weren't taken as seriously, and a lot of terrible things ended up happening to the victims of domestic. So now the tables have turned, and it is taken exceptionally seriously. Domestics is one thing, DUIs is another. Is taken exceptionally seriously these days. So yeah, absolutely, somebody's word could potentially land you in jail awaiting bail. That could absolutely happen.
Which is actually a really good segue into what we're going to discuss next in terms of landing you in jail, or let's entertain what's going to happen with Mr. Davis.
Okay,
Continue on. So we're talking about release now.
Yeah. So Mr. Davis slaps the police officer. Basically, it appears for no reason, as what the cop says. Maybe gets his ass beat. We're not sure, but probably.
Likely.
And then gets arrested on the spot. And after he gets arrested on the spot, Mr. Davis is then faced with the issue of whether or not or how he's going to be released. And even though, for example, Mr. Davis may have slapped a police officer in the face, and maybe the police officer even has a video of it or something like that,
right,
he's still innocent until proven guilty.
Regardless of the strength of the Crown's case, is basically what you're saying.
Yeah, regardless of how strong the Crown's case is, because until a court finds you guilty, you're always innocent. And that's a fundamental principle of our justice system. So he has the right to be released while he waits for his day in court and waits to be found guilty by a judge. So Mr. Davis, it depends on a number of things. For example, if Mr. Davis has a nasty record of slapping people unprovoked on like a regular basis, they're going to say, yo, this guy's a danger to the public. We release this guy and he's just going to slap some old lady down the street. Yeah. And we don't want that to happen, right? So they might try to keep him in jail. However, if, maybe there were some mental health issue or addiction issues that were affecting Mr. Davis that caused him to slap the police officer, that may inform, his very poor decision-making at that time. And that may justify him to be released while he's waiting for his trial. Maybe his lawyer is going to argue, that this guy was going through drug withdrawal, right? Or something like that. So he can be released in a number of ways, I think. Kayvan, you want to take over? How can he be released? At least if it was in Toronto.
Yeah. So it's interesting because, a case like this where you would think the Crown's case is very strong, which is one of the factors considered by a justice of the peace when debating whether you should be released or not. But, a great thing about our bail system here, and I've taken part in many bails, both as a defense lawyer and as duty counsel, and I've noticed that particularly in cases where mental health or drug withdrawal might be at issue, if there is a plan that could mitigate that could control that, then release is obviously favored. They tend to release the individual. And we have a number of programs here that I know the courts work with and whatnot. But the important thing is, if you flag that as an issue, to be able to provide a plan that will mitigate that, either a surety that will help that person get professional help, or an institution that provides that kind of help. Or, I don't want to get too technical, but that's the most important.
Let's actually bring it back a little bit. So before we move on, you've already said it. What is a surety? Why don't you explain that?
Sure. Yeah. Sorry. And I realize we're trying to make this, accessible to everybody out there. And to Mr. Davis. And I'm using these words. But, okay.
He's not the sharpest tool in the shed.
so-
So, I mean, you gotta dumb it down a little
Or
bit.
is he?
Or he might be, man. Maybe it's part of his big plan.
Yeah, that's it.
Yeah, so a surety. So essentially, the best way to describe a surety is it's the person who is responsible for the accused person in society. And the way I've heard it put is sort of your constructive jailer in society.
Right.
And that person ensures that you are following whatever conditions that the justice of the peace has set for you in your release order, in your bail. Oftentimes, there's not to contact with the victim or with the co-accused. So if there's a no contact clause, if you're not supposed to go somewhere, these are things that the surety keeps an eye on, and it's their responsibility to, if you do breach your bail and they become aware of it, to report you.
What are the 3 general surety responsibilities?
All right. So number 1, make sure that the accused person attends their court dates. It's done virtually these days, but
And often, if they have retained counsel, their lawyer goes
their
to
lawyer
court.
goes for them.
Exactly.
But the surety needs to be aware of when the guy's court date is. If the guy
Exactly.
doesn't show up to court, then it's the surety who's in trouble.
Absolutely.
Along with the accused person, of course. but-
The second one is to ensure that the accused person is following the conditions of the bail.
Okay.
And the third one, and I often say it's the most important one, that the surety needs to be vocal about this. If they become aware that the accused is not following their bail conditions, you've got to report them to the police, or you haven't discharged your duty as a surety.
Okay, so I think that's great. Everything that you've just mentioned is about running a bail or being released from the court. So we need to kind of bring it back a little bit. So Mr. Davis has gone arrested. So I think the very first thing we need to discuss is, in certain cases, I think you can be released what we call roadside or on scene. So Kabir,
Yeah.
what does that mean exactly?
It means sometimes, for example, in some cases, the police have the discretion to release you on the roadside. So say, for example, and this happens often with drinking and driving related offenses. Say you get caught drinking and driving, the police, they'll take you to the police station and they will, administer the breath test to you or whatever they need to do, but then say, go home. We don't need to keep you in jail. We don't need to bring you before a judge or a justice of the peace for you to get released. And that's usually for less serious offenses. And that's usually for situations where the person doesn't have a record or any type of history or failure to comply. I mean, the police do this often, even for simple assaults and stuff like that. The police will generally, look at the person and then consider whether or not to issue them what's called a promise to appear in court, which is just like a summons. They give you a piece of paper and say you have to come to court on this day. If they believe that you're going to show up and that you're not going to be fucking around when you're released, then they'll do that. And some more serious cases, sometimes they don't have that option. They need to.
So I think there's roadside and on scene, which would be, for example, if you commit, let's say, the dangerous driving or something like that, and the police come, you don't have a criminal record, whatever the case may be, they, at the roadside, which is where the offense took place, they can release you from there. Or let's say you fail to provide a breath sample, you don't have any history of offending, then they can give you this summons or the promise to appear roadside and say, come to court, here's your next court date, etc. And they can put some conditions as well. And then you have from the station, which is the example that you just gave, you're faced with a DUI, you need to go back to the station. At the station, you do a breathalyzer test where they want to figure out whether the level of your impairment.
Yeah.
And then let's say they charge you, they can release you from the station. And otherwise, for example, they come to a domestic incident, they bring you to the station from your home, they arrest you, bring you to the station, they try and get a statement from you. And then once that's all done and you've been processed, then they can also give you what's called an undertaking from the station. So we've got basically 3 prongs of release here. Roadside or on scene, at the police station, or taken to court for a bail hearing.
And let's not forget, what a lawyer can do is sometimes a lawyer can negotiate with the police officer to try to convince or at least persuade them to release you from the police station, even if they feel like taking you to court for bail. Like I've had many situations in the past where, for example, there's a guy charged with a bunch of break and enters, right?
Right.
The cop knows the case isn't that strong against the guy. The guy has a nasty record. And I'm talking with the cop and negotiating with the cop. And the cop is all like, we're going to take him for bail. We're going to do this. We're going to do that. And I put it straight up to the officer. Like, listen, I'm not available to do a bail hearing for this guy for 2 weeks. So if you want to go out and arrest him, you can find him and you can arrest him yourself, or you can surrender himself today and you can just release him.
Right.
Because he's going to get released anyways in court. Why are you wasting everyone's time?
Right.
Right. I mean, obviously, you're not looking for him. And that means that the guy might not be the most dangerous person. Like you're letting him roam the streets. Right.
Right.
So sometimes what I do is I try to get in touch with the investigating officer and say, hey, what's your story with this guy? Like, what do you think about this? And if you have a good relationship or you speak to them properly, you don't act like a dickhead to the police, like
right.
Mr. Davis.
Right.
Like there's a chance that, your lawyer can make a difference in terms of preventing you from, going to jail and sitting in the bullpen with a bunch of crazy people who not mentally ill, but people who are dangerous or whatever,
And that's an important too as well. I think what people need to understand is that you only want a bulldog lawyer in the courtroom. That's the time when it's appropriate to be what we would say is a zealous advocate. You don't want basically a dickhead or an aggressive lawyer with everyone at every stage at all times. And the bottom line is you catch more bees with honey than you do with vinegar. And being very respectful and cordial and building that relationship with police officers outside the courtroom is something that's necessary and something that we do. And it's exactly that. Let's say Mr. Davis got into a fight with a civilian and then went on his merry way and the civilian identified him and the police put a warrant out for his arrest. Well, you as a proper lawyer and advocate can call and say, listen, Mr. Davis didn't know. That's why he left the scene, that there was a warrant out for his arrest. He knows now. Why don't I arrange for him to turn himself in? And when you do that, that alleviates the concern of a flight risk, for example, from the police mind. And they're far more likely to release Mr. Davis from the station as opposed to bringing him in. So those are good things in terms of building these relationships.
So let's move on now. Okay, so say for example that Mr. Davis has been released in some form, probably after a hotly contested bail hearing. He's released. He's released, and now the court process begins. He's given a court date. What happens next?
So in terms of what would happen next is effectively a first appearance after his bail hearing or after a release of any kind. You have to have a first appearance. And Kayvan, what does that mean exactly?
So first appearance, just like it sounds, it will be the first appearance you will make in court to address the charges you're faced with. Now, generally, people who haven't dealt with the system, they get nervous. They think something of substance is going to happen at that first appearance. But generally, by then, you've retained a lawyer, hopefully, and your lawyer is going to make that first appearance, and they're going to put themselves on record, which means they're going to go to the court and say, "I am here representing this individual."
Like formally do that.
Exactly, right.
Until the court hears it, you don't have a lawyer in their mind, right?
Right, exactly.
So common questions, Kayvan, are from my clients generally are, do I need to attend my first appearance, and will the judge be there to listen to what I have to say? And what do you say to the clients?
So generally, no, you don't have to attend your first appearance if you've got counsel and if all the paperwork is in place. No, you don't. And the second thing is you that is not the venue you want to address the judge. Should that time come, your lawyer will let you know, but absolutely not. That is it's really an administrative appearance, and you're hoping to maybe get disclosure, which is the evidence against you, the initial package of evidence against you on that date or by that date.
Yeah, you don't want to go to court and start saying, I didn't do it
Absolutely.
right away. Because in this country you have an advantage where you are able, before you decide to say anything, to see all the evidence they have against you.
Yeah,
right.
That's what Kayvan was talking about when it comes to disclosure.
So, to that end, what we call this first appearance court, the courtroom is generally called set date court and then subsequently case management court. Kabir, how would you describe that to a civilian? What does that mean exactly?
So a set date court is basically, you're given a date and it's an administrative kind of series of court dates. So what happens is say, for example, maybe I'll explain disclosure first, because I think that's an integral part of set date court. So what you do is, like in Canada, and I'll use Mr. Davis as an example again, okay? So Mr. Davis now has his first appearance. Mr. Davis has the right to receive all of the evidence that the Crown Prosecutor and the police have collected against him. So one of these things is going to be obviously the police officer's notes and statement. The cop is going to say, I was just driving my car. I thought this guy needed help. I pulled over and stopped, and out of nowhere, he just slapped me in my face and said, fuck the police, and walked away.
Right.
That's what the officer's statement is going to say.
Those are some interesting memo book notes to read.
But it's a 3-liner, you know? It's the easiest memo book notes probably to read.
So what
Right.
are memo book notes?
So memo book notes are, police officers generally keep like a notebook with them where they have to keep times and dates and notes of what happened, because eventually at some point in time, they might be called to come to court and testify years later about what happened during this incident. This one's likely not one that the officer is going to forget, but if the officers are running like, you know, drug search warrants like 3 times a day and they've been doing that for like a year, it's going to be hard for the officer to remember, like, you know, what happened at, you know, Mr. Shabestary's clients, like, you know, drug search warrant, like, you know, where were the drugs found and all that. So they usually keep memo book notes for that. So that stuff like that, more disclosure can also include things like videos.
Right.
Like say, for example, the cop had an in-car camera, or maybe his radio
body
was
camera, for
or
example.
a body cam, yeah. Or like maybe there's some stores or whatever. There's a convenience store. Maybe there's someone just, you know, standing outside a store smoking a cigarette who watched this entire thing go down, and that person may have given a statement. So disclosure means you get all of that and you receive it generally at your first appearance, hopefully at set date court, and then then your lawyer has the ability to review it, or your lawyer must review it, and perhaps sometimes ask for more items of disclosure that they may not have included.
Right.
Okay, go ahead.
I think that's an important point, because it's not always about the disclosure that they give you. A lot of times it's about what they don't give you.
Yeah, man.
That's very important,
Absolutely.
right? So for example, in Mr. Davis's case, if the cop ought to have been, or was rather, equipped with a body camera that should have captured the entire incident, but lo and behold, the cop did nothing to trigger the body cam to go on, or that evidence is lost, whatever the case may be.
Or the body cam was never turned on, or something else suspicious, right?
That's a problem, right? That's such a small effort on the part of the police to have taken to ensure that was captured. And we say this at law, and I think it makes perfect sense. It's the best evidence rule. What you need to do as during your investigation is to capture the best evidence that you can to, you know, put the case before a judge. And unequivocally, I think a lot of people would agree, even the layman's persons understands that video evidence is very strong, and it's evidence that would potentially prove it. So you can't rebut that, right?
Yeah,
even
like we ask cops all the time, like, you had a camera on, why didn't you turn it on?
Right.
And you know, what going through my mind is, well, they didn't turn it on because things didn't happen the way they said they happened.
Exactly.
Because if it was on, maybe, you know, Mr. Davis didn't slap the officer that hard, you know,
right.
or like, you know,
maybe
it was
the
a tap
cop
in the
instigated
face.
it, or you know, or what if the video wasn't turned on when Mr. Davis was arrested, and all of a sudden he had 2 black eyes?
Right.
Yeah.
Or maybe the officer asked Mr. Davis, "What do the 5 fingers say to the face?"
You know, so yeah, and those are the things that we request all the time. Like, say for example, another good one is, say, you know, this officer has had a number of interactions with Mr. Davis in the past. You know, say this cop knows Mr. Davis, and maybe the cop began harassing Mr. Davis first, and you request reports of the officer's past interactions with Mr. Davis. You know, it might provide the judge with some kind of narrative to say maybe this officer and Mr. Davis has some bad blood, right? Maybe it wasn't unprovoked. Because even if, for example, even if he slapped the officer, the fact that it was provoked or unprovoked can make a difference in the sentence that the guy gets.
Right. And we'll get to that point for sure.
So, I mean, these are the kind of things that, you know, all competent lawyers generally do.
Right.
Right. So say, okay, fine. We say we get the disclosure, and maybe I should say this. Set date court is what you do is you attend court every 3 to 4 or 5 weeks, and the court asks you for an update. You know, Mr. Sharma, what's the status of this case? You can say, for example, I've requested this disclosure. I'm waiting for it. I don't have it yet. Or, you know, we're ready to go to trial, or we're ready to have a meeting with the Crown or a meeting with the judge. And so...
And why is the judge doing that?
Well,
what's their purpose? The judge or the justice of the peace? Why are they asking you these questions?
Because everybody has an obligation to ensure that cases move through the system efficiently, but fairly.
Right.
Right. You don't want to be in a situation where, you know, some guy's basically holding his dick in his hand and is like waiting for, you know, 3 days or 3 years
Right.
to kind of, you know, have his case move forward. The system will be clogged, right? They need to get rid of cases too.
In other words, you're attending court with the view to setting a date for a trial or a resolution or whatever,
Yeah,
for the
pleading
charges
guilty,
to be
whatever you wanna
withdrawn,
do,
and
yeah.
hence the name set date court.
Yeah, you're setting a date for something.
So you've received disclosure. Kayvan, when is an appropriate time for your lawyer to start reviewing your disclosure?
Well,
this is a question that comes from boss to employee. I'll give you a hint immediately.
That's right. As soon as I receive it, I drop everything I do and I create that memo. But no, all joking aside, it's important to review that disclosure as soon as possible after you receive it, because, you know, other things might come out of that disclosure, other items like Kabir was saying that you might want to request. And, you know, if it's video surveillance that might get re-recorded over, whatever the case may be, there's evidence that can...
That's time sensitive.
That's
Yeah.
time sensitive, exactly.
Yeah.
So it's incumbent upon a competent lawyer to review that disclosure as quickly as possible and identify what's missing and bring that to the Crown's attention. The Crown being the prosecutor, there's generally a specific prosecutor assigned to a case. And I think that's a good leeway into, well, what's the first actual substantive step that happens in your case, which is the Crown pretrial. So that's...
Before we get to the Crown pretrial, I want to discuss one thing. Obviously, you know, as lawyers, we like to pride ourselves on being very professional. We do our job right, and we fight for you tooth and nail. But there is one piece of disclosure document that individuals receive by the name of adult charge screening form. And I think that's an important document, regardless of where the matter is headed. And so, Kabir, can you tell us what an adult charge screening form is?
Yeah, so a charge screening form is basically the document that the Crown attorney or prosecution gives you that outlines exactly what you're charged with. It outlines for you how serious they are categorizing the case. Is it very serious or less serious? And then they proceed differently based on how serious it is. And it also outlines if they want like a DNA order from you, if they want like a weapons prohibition, if they want probation, and also the initial sentence that they're seeking.
Right.
So that's the most important part. So if you get a document for Mr. Davis, for example, you know, they charged him with felony battery, so they're treating that as the more serious one. In Canada, that would be something that we call by way of indictment, assault. And the charge screening form for Mr. Davis would probably say something like 90 days jail, I would say.
Okay.
For something like that.
So what I'm interested in knowing is that, for example, as a lawyer, you receive the charge screening form on behalf of your client. You know effectively now what the Crown's starting position on resolution is. And lo and behold, instead of the 90 days, Mr. Davis is getting a suspended sentence or a conditional discharge, which we'll get into later. But it's lower than you had anticipated. What does that information potentially relay to you as the lawyer?
Well, it's simple, that there's something wrong with the Crown's case.
Right.
That's what it tells me.
Yeah.
For example, if I have a guy that's, you know, charged with like a shitload of drugs, and then they offer some super lenient sentencing position, like off the bat, I know that there's something fishy going on here.
Right.
Either there's like maybe a dirty cop, or like there's like some issue with the search warrant, or like whatever the case may be.
Right.
So,
I can't imagine that would always be the case, though.
No, it might always be the case. Maybe they want to get rid of the file.
Right.
You know, maybe they're busy or something. Like, who knows, right? But immediately what it triggers to me is that, you know, there's room possibly for negotiation here to go down, or the case is weak. Right.
Or at the very least, it triggers to you that, you know, you need to have a really careful consideration in this case of what's going on and why they're offering it. Because a lot of times it could just simply be systemic as well. It could be something that the Crowns are telling the assistant Crown attorneys, which is, listen, we've had an influx of these cases, DUIs, there's been an influx in them, for example. Why don't we try and resolve more of them? The courts are backlogged. We need to have trials that are more serious going ahead rather than, you know, super low offending. So let's try and resolve these as much as we possibly can. So that could be another reason. It's not always going to be, but certainly that triggers it as well, which is going back to you, Kayvan. That's a good segue into discussing these things with the Crown with some view to strategizing the case, not always laying your hand out there. Right. So what's the first step? What
would you do for Mr. Davis here when you're having? Explain to me what you would what you would do to help Mr. Davis at a Crown pretrial.
Well, number one, I think the most important thing is for you to know your case and your client very, very well ahead of the Crown pretrial.
So tell us first and foremost, that's absolutely the perfect observation you've made, but what is a Crown pretrial?
All right. So the Crown pretrial is the first discussion that your lawyer is going to have with the Crown to discuss, what's going on with this case. First of all, what if you're, as the lawyer, there's still missing disclosure, you want to bring that to the Crown's attention. If you're looking with a view to resolve or set trial dates, you want to gauge the Crown out to see where they stand in relation to what was on that charge screening form as well. Because, it's not always does the Crown stick to that charge screening form if you know your case and if you're able to make a case for your client and his or her circumstances, you might even get a better position out of the Crown at the pretrial. But the most important thing is for you to know the circumstances of your client and the case, so that if I'm going into this pretrial and I'm thinking, okay, the Crown's case is really, really strong. There's dash cam footage of Mr. Davis. It was completely unprovoked. Let's look at the circumstances he's suffering. Does he suffer from mental health illness? Is he doing any upfront work to address that? What that means is he getting any help in the interim to address
voluntarily is he
exactly
doing it?
What's triggered you to think that Mr. Davis might be suffering from some mental health issues here?
It's not every day that.
Let's pull out the laundry list here. Maybe slapping a cop unprovoked might be the first one.
Generally, that would trigger to me. There is an issue there.
That or that guy's a G, one of the two. We'll put a poster of this guy in the office.
And I think it's important when you do that. And also on the flip side, let's say that wasn't the case where he's on dash cam and all this. Let's say there are holes in the Crown's case, and let's say Mr. Davis ended up injured after he was arrested or whatnot. Well, if you know your case very well, you could strategize, as you were saying earlier, whether you want to show your hands or not, but to discuss with the Crown in such a way to let them know, hey, listen, your case isn't that strong, so let's talk about maybe a non-criminal resolution. Like, we're going to get into these conditional discharges and all that afterwards. But the bottom line is know your case, know your client, and be able to speak about it substantively at the Crown pretrial, because you put the Crown on notice that you know what's up.
Right. The other thing that I find can be very helpful, this is something that I do, is that obviously you know your client, know your case, but a lot of lawyers kind of treat a Crown pretrial as like a just another step in the procedure. Right? They don't really treat it as something important because it's required, and a lot of times it's treated like a formality. However, what a diligent and competent lawyer does, which is what I do, of course, I ensure that if I can get reference letters, if I can get some letters to show the character of my client, I can tell the Crown, listen, you can look at them. I'm not going to give them to you to use. It's called giving documents to somebody without prejudice. It means they can't be used against you later on. You provide the Crown with these documents. And what I find works really well is sometimes the Crown has to come to a decision, and for them to do that, they need to go to their superior or their management to get approval of what you're asking for. Sometimes what I do is I do all the work for the Crown. So I write an email and I say, for these reasons, and for these weaknesses in the Crown's case and these potential consequences that are maybe disproportionate to what my client has done, and these letters justify, perhaps a withdrawal of the charges if he does some counseling. And you provide that like in an email to the Crown sees it and says, man, like my work's already done for me.
Exactly.
I'm just going to forward this to my superior and see what happens. And I find that's the best way sometimes to get a positive result for a client. And a lot of lawyers don't treat it like that.
Can I, I'm sorry. I just wanted to do a quick side story here, because when you said without prejudice, and so what that means is you are able to have discussions with the Crown openly, and it's not going to be used against your client, as you said. Now, when I worked at this chambers for a bunch of lawyers, one of them had written me a reference letter for my articling, And without realizing it, that on that reference letter, it said without prejudice, which was something that came up in a lot of my interviews where they're like, this is a reference letter, but it says without prejudice on it.
I can't use it. What are you able to do with this?
So yeah, that was a little embarrassing.
Yeah, that's a lawyer who just took another letter that he had and just wham, Kayvan, write your own reference and let me sign it.
So I think, much like we say that that's what sets a good and a great lawyer or even a good and bad lawyer apart is being prepared. So preparedness is something that's crucial and important. And I think what that does, you hit an important point, Kabir, which was that the important point that you've hit there is making their job easy for them. So by the same token, when we say we have lawyers who are prepared and those who are not, and you set yourself apart by being prepared for your client, Crown attorneys can also be busy and unprepared. There could be very often Crown attorneys that have so many cases on their desk where
they have hundreds at the same time.
Where a poochy little domestic or a case that's not the most serious on their Rolodex of cases might not get the attention that it requires. So they themselves might not know the case at your Crown pretrial. And what you're doing when you're so well prepared is dictating to them what the case is about.
You're telling them what their own case is about. Exactly.
And they will take notice of that. Obviously, I think it goes without saying that we're all officers of the court, which means that we have an obligation not to mislead. We can withhold information that we have, but we can't lie or mislead. And I think, a lawyer with integrity knows that. And if you have a good relationship with the Crown and you've established good rapport, then they know that and they trust you. In other words, if you tell them this is what the case is about and this is what I've done about it, then they will believe you and they will take you at your word because you're an officer of the court. There's been many instances under which I've had cases where I'm asking for something that's a little bit above and beyond what the Crown would otherwise feel comfortable offering. My client's already done the upfront work I've asked them to do voluntarily without anybody telling them and by anybody, I don't mean me. I mean the judge, the Crown or something like that.
Yeah, you don't have someone ordering them to do something, but you're telling them, get this counseling done.
And I have a discussion at the Crown pretrial with the Crown and I say, this is what I want. I want the charges thrown away because my client doesn't have a criminal record. He is remorseful or he's done what he can in order to address rehabilitation. And what I always do is I follow up a Crown pretrial with an email. And that holds two purposes. The first one is that you now have a written record of what you discussed. A lot of times things could just be
misinterpreted.
Lost.
You didn't say that to me. Exactly. I never agreed to this.
So one, it's to put that in writing. What was the discussion? What were the agreements? You put it in writing. And two, when you put everything summarized neatly for the Crown in that fashion, a lot of times I will show up to court for the resolution date and the Crown is reading or justifying the position to the judge and they're pretty much, they have a plug and play from what I've sent them on the record.
And they're just reading what you wrote them to the judge? Yeah.
And I've even had a Crown, joke with me and say, I shamelessly just plugged in what you wrote. And that's the whole point. You're making their job easy for them. And you want to do that. You want to do that with
beneficial
Crowns.
To your client,
100%.
Right?
You want to do that with Crowns and you want to do that with judges as well. And so I think that's a pretty good segue into the next step. So some cases, let's say you're not able to resolve or there's a disagreement or you just need some input. Yeah. What happens after a Crown pretrial?
Yeah, so basically you go to the Crown and you say, Mr. Davis has all of these problems. I think that, he shouldn't go to jail. And the Crown looks at me, laughs in my face and says, fuck you. He slapped the cop unprovoked.
Right.
We're not.
Or maybe Mr. Davis says, I didn't do it.
Yeah, that's another one too. I totally forgot about that part.
Yeah.
Mr. Davis said, I didn't slap this cop. And the Crown is not accepting that at all. So what happens next is there's obviously a disagreement between the Crown and the defense on a central part of the case, which is, did Mr. Davis slap this cop in the face unprovoked? Yeah, in that instance. So when there's a disagreement like that, the only option when it's a disagreement that's that serious is either we get some input from a judge or we take it to trial, right? So what normally happens after that is the defense and Crown say, listen, this may go to trial or we may need some input from a judge. So what we'll do is we'll schedule a meeting with a judge.
Right.
And that meeting with a judge is called a judicial pretrial. And just very briefly, what happens is the Crown, the defense, and a judge have a meeting in like the judge's office. Now it's done virtually, of course, but have a meeting. It used to be in a judge's chambers, where the judge basically asks, what's going on here with this case? Why do you guys need me? And you say, basically, we're not agreeing on this. This is going to go to trial. Or, I want to pitch this kind of a sentence to you based on all these issues. The Crown's not agreeing with me. What do you think about it? And sometimes the judge may say, you know what? Mr. Sharma, I agree. I think your position is reasonable. You make good arguments to me, and I might give you what you want. Other times, there's basically no agreement, and you set the matter down for trial. So what I'll go to, or what I'll ask Kayvan is, Mr. Kayvan employee, how do you prepare for a judicial pretrial? Tell us that.
So again, at this stage of the game,
for Mr. Davis, how would you do it for Mr. Davis? Let's do it like that.
So at this stage of the game, let's say Mr. Davis's matter is headed to trial, right? What you need to have down and have it down well at your judicial pretrial is, how long do you think you need for trial? What pretrial motions are you bringing? So, for example, if Mr. Davis was in fact beat up by the police after he got arrested, we might be arguing that his rights were breached. There's, the Charter of Rights and Freedoms, and, without getting into too much detail about that, because that could be a whole episode on its own, but, if his rights were breached, we want to bring this to the attention of the judge before the trial to say, hey, listen, is it such a bad breach that his charges should be stayed, that the prosecution shouldn't continue, or that any evidence against him should not be included? So we're looking at what pretrial motions are there. Another pretrial motion that I ran into recently was whether we want to get a witness traveling here all the way from let's say British Columbia to Toronto, or is that going to be done virtually? So that's a motion. We're saying they have to come in person. The Crown is saying that they want them here by Zoom. So these are all issues you discuss before going to the trial, and you got to provide estimates. How long do you need for them? How many witnesses do you intend on calling? And what are the legal issues that are going to be raised? You don't have to give your whole hand away at the judicial pretrial, but you got to let the judge.
Even though sometimes they try to force you to do
that.
Absolutely. But
absolutely.
if you're an assertive lawyer, you have to hold your ground sometimes because they're trying to squeeze out as much information as they can out of you.
Or admissions.
Or admissions. And that's another big thing at the judicial pretrial. There are certain things that maybe your defense counsel would admit because it would be very hard for the Crown to prove.
So for Mr. Davis, give an example of what you would admit. For Mr. Davis,
let's say... jurisdiction would be admitted.
That's a great admission.
Jurisdiction means is the court able to even hear this?
Exactly?
Like you don't want you don't need the Crown to call.
He slapped the police officer.
Yeah, I'm pretty sure that's criminal.
Yeah, I'm pretty sure that's a criminal case. What about identification?
So that's an interesting one. That's a really sorry. Go ahead.
No, would you admit ID in this? I think I would.
I would too.
Listen, I think I would. In this
Mr.
particular
Davis
case,
coming and saying, well,
right.
I had a twin brother.
Right.
He ran away. I came. The
right.
officer he had his head down after he got slapped and he thought it was me.
Right. And then what's the officer going to do? The officer's not going to show up and say, oh, it's not that guy. All he's going to do is say, yeah, this is Mr. Davis. He slapped me in the face and I arrested him.
Officer, did you put yourself through a photo lineup?
So in a case like this, of course, ID would be admitted. But, I think lawyers, particularly competent lawyers, should really, really make sure before they admit ID that there is no other way that it could have been anyone else, because ID is a big thing. And a lot of people think, for example, this accused person, he was caught on camera, so obviously you have to admit ID. No, not necessarily. There's a lot of issues with surveillance, let's say. So
I think they should clarify that. So here's the clarification with that, okay? It's not just whether it could have been anyone else. The Crown has the onus of proving ID.
Absolutely.
And they either can or they can't. And the bottom line is, you don't have to make a suggestion. You don't have an onus to make a suggestion that it was or could have been somebody else. All you need to do is put the crown to their onus to prove that it was your client.
That it was your client, not that it wasn't him.
They haven't met that, right?
Absolutely. And like in the context of a domestic where two people have been married for 20 years and something occurred, well, it's not that hard to bring the complainant or the victim on the stand and say, well, who did this to you? How do you know him? Like that's
yeah,
an
well,
issue.
You know what? Let me tell you
a
story about that too. So same situation. It's a domestic assault. I mean, the assault itself is caught on, I believe it was caught on video, but it wasn't that great. And I admitted the identification of my client, because I think the whole issue of that trial was, was it my guy who was in the bar that did this? That's what wasn't clear. And I anticipated that she was going to come and say that it was my client who did this. So I admitted ID. And she shows up to court and trial and says, I don't know this guy. I've never seen him before in my life. And I had admitted ID. Thankfully, I had a good crown that said, okay, obviously this case is a piece of shit.
Right.
And they ended up withdrawing it anyways, because there are probably a lot of other problems that come along with that for them, at least, because they have an obligation to treat everyone fairly. The crown's obligation is not to win. It's to make sure that justice is done. And if you have a situation like that, it's kind of like you got screwed a little bit.
So the audience and the prospective client, if I was a civilian just listening to this, I would think right now to ask the question, why would you ever admit anything?
Well, see, that's a good point. And, there are a lot of lawyers that don't admit anything at all. And that's for a variety of reasons. But what happens is it's really important to keep a rapport with the judiciary, because one of the things is when you're a defense lawyer that's, a busy defense lawyer who's in court all the time, you see the same judges and same crowns all the time. And one of the benefits that you get is if you're seen as somebody who's reasonable, yet still a competent and zealous advocate, like you don't make issues out of bullshit all the time. Yeah. If you're one of those lawyers that comes to court and takes the throw shit at a wall and hope it sticks approach. Nobody likes that, and then nobody is going to respect you or treat you credibly. So sometimes you make these admissions if you for sure know that the Crown's going to be able to prove this one element, you make the admission. People think you're a bit more reasonable. It helps your client as well, because
it adds credibility to the other arguments that you want to make.
Exactly. So, in other words, pick and choose your battles.
Absolutely.
Yeah. So there's a perfect example here. Sometimes, I just throw my hands in the air and I say, listen, my client's not been reasonable. They're not admitting this and that, or whatever the case may be. And sometimes, like Kayvan said, that's okay, right? Because if you want ID admitted and you're talking about a domestic, and they've known each other for 20 years, the victim, the alleged victim and the accused, fair enough. It's an unreasonable admission not to make. But what are we trying to do? What is a judge trying to do? They're case managing. In other words, they want to save resources as much as possible while protecting the integrity of the process. And what that means is that they try and shorten the estimates or try and give an accurate estimate so things don't get out of hand. You don't all of a sudden have a 6-week trial scheduled for a simple domestic. That would be absurd. So the answer to that is, yes, it might not be the most reasonable admission not to make, but how long does it take to get that out in evidence?
Exactly.
The person's going to come and say, he was my husband. The alleged victim is going to come and say, he was my husband of 20 years.
This is the guy that hit me.
And this is the guy that hit me. And do you see that person in court here today? Yes. And where are they sitting? Right there beside his lawyer who's asking me questions.
What's the real
seconds.
That's why, I 100% agree with you. I think you're right.
But there are some instances under which a simple non-admission can really get out of hand. And I think where that happens very frequently is continuity. And continuity means once something is seized, for example, let's say drugs are seized by the police, what happened after the seizure until the trial time?
Until it shows up in court. Who handled it, where it was. Because I think the goal is to make sure that what was seized in whatever that house, those drugs that were seized, are the exact same drugs in the exact same fashion when they're brought to court and presented as evidence. Mm-hmm. So every person that's touched those drugs or where they were stored or where they were held, you need to maintain the integrity of that. It's called an exhibit.
Right.
That's the point I'm guessing that you're getting at, right?
Yeah.
Sina?
And it's just, not frivolously going down every rabbit hole. Unless you have some indication from your client or something is happening in the case where continuity might be at issue, from my perspective, I know other lawyers do things differently, but that my perspective is I try and find the essence of the case and I stick to that.
Right.
And that's what I want to litigate. And you get some credibility with the judge and even the Crown, that they listen to you more with the things that you have to say rather than talking about everything. And unless absent something that's glaring at me in the case, I can't take this position that on every case the police are, they're doing something shady, or that they're not handling the evidence correctly, or whatever the case may be.
Usually it's because they're like lazy, right? Like, for example, like I had a case where there were all of these drugs seized from different places in the person's house.
Right.
A lot of it was found in one backpack and some were found in like a cupboard or whatever. And there was a question as to if my client lived there or not. And what the cop did is the cop just took all the drugs that he found and threw them in one box.
Yeah.
And I wanted to know what drugs were found where, because what if someone else left that backpack there?
And made no notation at all.
No anything. So I'm sitting there, I'm like, listen, man, like I need you to tell me where this drug came from the house.
Yeah.
Where in the house? I don't know, somewhere in the house. So that is an issue I feel that has to do with continuity of like.
And I think you're entitled to explore that. Conversely, if you have an officer who's an exhibits officer who's been there, who's followed around, he's videotaping the search or he's taking photographs of the search and he's following around every person who is seizing something and he's making a notation of that officer, their badge number, where they were in the house, and they're giving you this beautifully drafted exhibits list, then continuity is likely not going to be an issue there.
He's doing his job properly.
Exactly. So why are we wasting 3-4 days of court time calling a dozen officers to say I took the drugs from here and put it there, I took it from here and put it there? It's just, you're not going to get a lot of credibility.
And hence where really knowing that disclosure inside and out comes at play, because you'll have a good idea of whether the police might have dropped the ball on this one or not.
Exactly.
By going through their memo book notes with a fine-tooth comb and really, really understanding how those notes were written, whether there's indication of collaboration or not, and so on and so forth.
So I think, the JPT conclusively is at a meeting that you have in chambers that's not recorded when you have a lawyer.
Without prejudice.
It's without prejudice. Yeah. And you're basically discussing two things. It's either you're discussing resolution, in which case you're asking the judge, hey, if we were to put this sentence in front of you, is this an appropriate range?
And let's make it clear, the judge at the judicial pretrial is not the judge that's hearing your case at the trial.
Yeah.
I think that's important to know, because that judge is going to hear things about your client and about the case that a judge who's your trial judge shouldn't necessarily know, because they should come to your case with a fresh mind. But anyways, continue. Sina.
So there's a lot more that we can talk about here, but I want to move it along for sure.
Let's talk about Mr. Davis quickly, okay?
Right. So Mr. Davis, is he at the judicial pretrial? Is he resolving or not?
I'd say Mr. Davis says he didn't do it.
He didn't do it. Perfect. So we're going to trial, right?
So, yeah,
so
we're going to trial. The cop is a liar. This
Right.
guy lies all the time. He didn't have his video on.
So how many witnesses are there?
Well, I would say that there's at least one, which is the cop.
And for the defense, how many witnesses are there?
At 0 to 1, I would say.
0 to 1.
Yeah,
And what is this 0 to 1? Explain that.
So what happens is, okay, first I'll explain basically, I'll explain what a trial is, okay? A trial is when a judge is basically deciding whether or not you're guilty of the offense. And this can happen 6 months, 7 months, 8 months, maybe a year after you've been charged. And actually in Canada, they have up to 18 months to prosecute you at a lower level of court.
Right.
So the trial judge is, what the Crown does is the Crown attorney says, Your Honor, this is the case that I'm presenting. I'm going to be calling this person. And then that person, the police officer, basically says his side of the story. Then Mr. Davis's lawyer would question the police officer. And then Mr. Davis decides if he wants to testify in his own defense or not. He can choose to. He can call witnesses. The Crown can call more witnesses. But eventually what happens is the judge hears and assesses what the person in court was saying after they've been cross-examined, what their testimony was, to see if they're being truthful or not. The lawyer makes the argument, and then the judge comes to the conclusion. That's what a trial basically is, and that's basically the conclusion of like the criminal process for a lot of people.
And in terms of timing, we're assuming here that Mr. Davis is been charged with assault simpliciter. It's a simple assault, and it's a matter that's running in the Ontario Court of Justice. So to that end, Kayvan, can you tell us the three types of offenses in the criminal code?
Summary, indictable, and hybrid.
That's right. And what does that mean exactly?
Yeah,
Well,
I was on the
learned
spot
well,
there.
man.
Wait a minute, what's
It's like,
what
oh shit,
you
what's this guy
asking?
talking about?
Kayvan's got PTSD from the bar exams.
So it essentially boils down to the seriousness of that charge. So summary charges that are offenses that proceed by way of or proceed summarily. They proceed in the lower courts. You don't get a preliminary hearing. You don't get the option of a judge and jury trial. And the maximum sentence are often, they're lower than that what would be on an indictable offense. So let's say assault simpliciter, that would be, that's proceeding summarily, would be, a slap in the face or something like that. Now, there are offenses that are straight indictable.
Like for example, selling drugs,
right?
Like
or
drug dealing offenses and
robbery with a firearm,
even general robbery.
Straight robbery.
Yeah.
Straight
Like
indictable.
you snatch someone's chain off their neck in like high school, or you for example,
as one does, of
As
course.
one- as one, has seen before, but maybe you take someone's lunch money. That's considered a robbery, and no matter how serious the robbery is, it's always treated at the high end.
Right.
So that's by way of indictment.
Right.
Right. So Kayvan, what is that? What's the procedure when someone's charged by something by way of indictment?
Well,
In other words, either the offense is straight indictable, where there's no election for the Crown to make, or the Crown chooses on a hybrid to proceed by indictment. What does that mean?
So if it's proceeding by way of indictment, then you've got a choice. The client has a choice. Do you want this to proceed in the lower court, or do you want it to proceed in the superior court?
Lower court being Ontario
Court of Justice versus the superior court,
Which I like to call high court.
Right, high court, yeah. And that's an election. That choice is called an election that the accused person makes. Now, what comes with that election?
High court for the Court of Appeal, and then is it the Supremes?
The Supreme Court.
The Supremes. And so if you're proceeding in the higher court, which is the superior court, you have the option of a judge and jury trial, a jury of your peers. And the other important thing is a preliminary hearing. Now, offenses which carry a maximum term of 14 years or more are eligible for what's called a preliminary hearing.
Right. And that's relatively new.
So that change in law for the 14 years or more is relatively new. But what that does is that's essentially the venue before the trial where the evidence is tested to see whether there is any evidence on which a reasonably or properly instructed jury could return a verdict of guilty.
Attaboy.
Thank you very much. So essentially it tests, now that standard is very, very low. It's not difficult for the Crown to
show there's some
evidence. It's a very, very low standard, but it also gives defense counsel an opportunity to cross-examine some Crown witnesses at the preliminary hearing and then create a record of that so that those same witnesses are then cross-examined at the trial to see if there's any inconsistencies between the testimony of those witnesses at the prelim versus at the trial. So for cases proceeding by way of indictment, and for those that have 14 years or more, you get that prelim, you get your judge and jury option. And for cases that are proceeding summarily, as we said, it's in the Ontario Court of Justice, and you don't get any of those. You don't get a jury, you don't get an option at a prelim, none of those.
But usually they try to sweeten the pot by saying, it'll be a way lesser of a sentence when the client's found guilty.
Exactly. Yeah.
And that's, frankly, that's not false, because
no, it is true.
I would imagine that Ontario Court of Justice judges are more inclined to give lesser sentences because they're usually, for the most part, they're
not
trying,
dishing out life sentences
right,
like how they are in high court.
And they're trying less serious offenses.
Right.
Whereas you go to superior court and you have the serious drug busts, you have the serious sexual offenses caught with violence, you have the robberies, you have the murders, the attempt murders.
Yeah, for them, like, putting someone in jail for 6 months is a kiss. But and
not very likely.
Yeah.
But you go to the Ontario Court of Justice, 6 months is a pretty significant sentence. It
can be. I mean, I've had cases where
you got your client how many years?
Got 6 years was considered a kiss. In SCJ.
Man, you're a great lawyer.
I was gonna say I've had cases with the OCJ where
listen, man, it's all relative. If you're getting murder reduced to a manslaughter and all of a sudden you're sitting at 6 years, that's a single digit sentence. You've done a fantastic job for your client.
That is. You can do that time standing on your head.
Just real quick too. I wanted to say about hybrid offenses. It's what it sounds like. It could go either way, and it's up to the Crown to choose whether they want to proceed by way of summary or by way of indictment.
So, let's say you have a case where the Crown is proceeding by indictment. The maximum punishment is not 14 years or more, and you have an election to make, okay? In these instances, Kabir, sometimes I think you can elect down, as we say. What does that mean, and why would you do that?
Like elect down back to the Ontario Court of Justice?
Correct.
Because you get a good judge. That's why.
Well, that might be one thing. But the other thing is that it's proceeding by indictment. The maximum punishment isn't 14 years or more, so you're not getting your prelim anyway. You're not getting a prelim,
right?
So why would you want to go straight to the SCJ? And when you're
sometimes you want a jury trial though, bro, because 100%. Imagine like you have a jury for Mr. Davis's case. It's a community that really hates the police. Right. And the jury you're going to get is a jury that's been over-policed and abused by, the police for a long period of time. And you want Mr. Davis, when he testifies in his own defense and gets up there and say, I didn't do this cop is a liar, right? Who knows? The jury might have had these experiences with the police before, and the guy might get acquitted. So, you know what I mean? So, that's something that... That's
that assessment. The assessment is very factually driven.
Right. And that's the big difference, right? Where I have something that's a case that's really particular on the law, and I need someone who really understands the law exceptionally well, I generally would opt for a judge alone.
Yeah, me too.
But something fact specific, I would want a jury. And a perfect example, I had a case of, it was an allegation of a vicious sexual assault. And the allegation was that my client had sexually assaulted this girl 5 times in a span of 20 minutes in the front passenger seat of a Honda Civic. Okay. And she had, both in her initial statement and at the preliminary hearing, testified that not only did he ejaculate each time during the span of this 20 minutes, but that his semen also smelled of kerosene. Okay.
Wow.
So needless to say, it was unbelievable. There were obviously, of course, a lot of other credibility and reliability issues in this case as well.
Dude, 5 ejaculations in 20 minutes,
right?
I was like, I don't think you need an expert to figure out.
Well, here's the thing: I was relatively.
Can you take judicial notice of the fact that that's impossible?
Hi, I'm Superman.
Yeah, exactly. I was relatively young counsel, and at the time, what I wanted to do was get an expert to talk about the refractory period for men. In other words, how long it takes for you to be able to reload after you've busted your load already. And some senior lawyer I was talking to about this was like, you don't need an expert. All you need is one man on that jury. So
even a woman, man.
I had a female judge for my judicial pretrial, and she facetiously said at the JPT, there's going to be a lot of people who are wondering what your client is eating for breakfast. Triggering to the Crown, there's some issues here. Nonetheless, the Crown didn't withdraw the charges initially. Seriously, they didn't withdraw the charges initially. I said, we're going for a jury trial. They offered my client a peace bond. I encouraged them to turn it down, and they stayed the charges.
I remember that. I was working for you as your student,
summer student. Yeah.
I fucking love to have a case like that. Oh man, that jury submission would be beautiful.
I was looking
ladies
forward to
and
the
gentlemen,
jury trial.
do you think this is true?
And the other thing I did in that case, and these are the things that I think lawyers can do to go above and beyond. And You know, Sean Gill, who was one of my articling principals, actually taught me this, and this was an invaluable lesson, which is do your investigative homework yourself. Go to the scene of the crime and look at, you know, the car, or if you can, look at a similar car.
How did you investigate the refractory period?
So what I did actually was I went because she had said that there were other cars that had gone around, and that her version of events was that he was basically parked in the center of the street. So I went to the street that was the subject of the allegation, and the street was so narrow that it made it impossible for that to have been the case. So even in a case where you're talking about sexual assault, you would never think that, you know, the width of the street would have any relevance, but of course it does. Everything is relevant in terms of what the individual is saying.
She's either lying or she's not reliable.
I
Exactly.
remember another thing that you had done in that case too was you really analyzed the car where she alleged this happened.
Yes.
Because somebody who ejaculates so many times in a vehicle, yet there's absolutely zero
Nothing.
DNA
Yes.
found,
Yeah.
is
And
so
they-
unlikely.
And that's the thing. The police had searched that car.
Right.
They had went after DNA in that vehicle,
Right.
and they couldn't
yeah.
find any.
And you looked at exactly like how did she say they were placed? Where would this DNA have could have been like? Did
and
the
even the
police look
dynamic,
there and
even
all
like
that?
my client he was a big boy. We're
Yeah.
talking about a small
Small
car, a
car,
Honda
yeah.
Civic, and she was saying it was in the front passenger seat. I'm like, and she wasn't exactly a small girl either. So
Right.
it made the optics of this alleged vicious rape almost impossible.
Yeah.
So
So
okay,
in the
let's
final
keep it. Yeah,
moments-
let's.
Yeah.
I say we just keep it moving.
Yeah.
Let's talk about Mr. Davis. Okay, if Mr. Davis is believed by the jury or the judge, he's acquitted, gets to go home. Obviously, he lives with the stigma of his name being in every news article, but for a great reason, I feel. But then say he's found guilty.
Yeah.
All right. What happens next? Kayvan, I'm going to turn this one over to you. You're really good at that.
The 606 specialist.
Well, 606 is plea comprehension, right?
it is.
So it's
So I'm not saying he's
you
not
know.
pleading guilty.
Yeah,
Say
yeah,
he's
you're
found
right.
guilty.
Yeah.
Let's talk about the sentence.
So sentencing. What generally happens at sentencing is like these guys said, you've already been found guilty. Now we're going to talk about what's called the mitigating and aggravating factors of what occurred, so that the judge could consider it in considering the overall sentence. Now, there's a whole lot of there's a whole lot of elements to the sentencing, and I don't want to get too technical. So,
Speak about the 718 principle, the denunciation,
Yeah.
the deterrence.
You know, the judge has to take a couple things into account. Are you Googling that, sir? Jesus, fuck. Look at this guy.
You know, I'm not
I think we need a
Googling it
memo on
because,
Monday morning, sir.
There has to be parity in the sentences. The sentences
proportionality
Right, there's
is-
proportionality involved. There's denunciation. There's deterrence. So these
Talk
are
about specific in general as well. What
Yeah.
the difference is. And
Maybe,
explain.
okay, I'll start and Kayvan, you can feed off me, okay? What the judge needs to do every time they sentence somebody is they need to take a couple of principles into account. Like the most important one is that the circumstances of the offender and the circumstances of the offense have to be considered in relation to like the act itself to make sure it's proportionate. So the sentence always needs to be proportionate to the act and the offender. So that is basically the golden rule of sentencing. But the judge also needs to ensure that there are a few other principles that are followed when they're sentencing somebody. And sentencing somebody, it could be jail, it could be probation, it could be a fine, it could be whatever. But the important criteria are that you need to first satisfy the principle of, or a consideration, it's called deterrence. Number one, when a judge gives a sentence, they have to ensure that the general public is deterred from, for example, slapping a cop. So the sentence imposed has to be significant enough so that the general public feels that if they slap a cop, they're going to get slapped with this sentence.
Right.
There's also specific deterrence, which is to tell Mr. Davis,
Don't do this again.
Yeah, you better not slap a cop again. So I'm going to impose this sentence to deter you from doing this again.
All right. And how does Mr. Davis's specifics play into this? So, for example, if Mr. Davis suffers from a mental health issue, or if the circumstances of the offense, which is something we talk about a lot at the sentence, on one hand, Mr. Davis is of sound mind. There was nothing going on. It's just inexplicable. There's no explanation as to why he did this. Or conversely, Mr. Davis just had his, a family member, shot
Right.
and arrested erroneously or something like that by the hands of the police. How do those come in play?
So yeah, when I was talking about the mitigating and aggravating factors, so those are factors that could mitigate in favor of a lower sentence for him. For example, Mr. Davis suffers from mental health issues, or Mr. Davis had just undergone a traumatic experience, or whatnot. Versus aggravating factors, if this was completely unprovoked, if Mr. Davis did this out of a sense of general just revenge or disdain for law enforcement. These are factors that the judges could balance in his mind. And one of the other principles of sentencing that I want to touch on that could, be relevant here is rehabilitation. We talk about denunciation, we talk about deterrence, we talk about deterring society in general and specifically the individual, but we also need to remember that especially in our judicial system here in Canada, rehabilitation is taken very seriously. We want offenders to become rehabilitated and become productive members of society. So an unduly harsh sentence would actually go against that. So it's a balancing of these factors. And in my defense, if I had to refresh myself on Google, it's because I don't do a lot of sentencing. I tend to win my cases or get my charges withdrawn. So
that's what happens when you get easy cases, tough guy.
Well, aside from being Mr. Sharma's hero, what does Mr. Davis get? What do you think he gets in this case?
I think Mr. Davis, I could probably argue for Mr. Davis to get no jail. I think I could probably do that.
Right.
If I make him do some sort of counseling. Mr. Davis doesn't seem like the kind of guy who would do counseling, which I think would be a problem. He doesn't seem like somebody who is, really apt. Hopefully he's a drug addict. I mean, that'll help him.
If he was a drug addict and he had no priors, could you get him a
non-permanent criminal record?
Yeah.
Ooh, I don't think so, man. I think that'd be a rough one. I think most judges, unless the guy had serious issues, man, most judges would give that guy a record for sure. I think.
It depends. I think it depends on the judge. In other words, I think to kind of finish off here,
DOJ depends on judges.
Sentencing is, what they say about sentencing is that it's not a mathematical equation. And in fact, unlike any other area of law, they say that sentencing is an art. They don't refer to any other area of law.
And Kayvan is Picasso.
As an art. So that just goes to say that it's very, very specific to the case. So it's on a case-by-case analysis.
So everyone, I'd like to thank you all for listening to our podcast. If anybody's made it this far, hi, Mom. Thanks for listening to my podcast. I appreciate it. If you guys have any input or anything like that, we'd love to hear from
any questions or any ideas about future episodes, what you want to hear about, you can hit us up. How can you hit us up, Kabir?
Instagram at Titan LLP, Twitter at Titan LLP, www.titanllp.com. We're on Spotify, Apple, YouTube. Oh, YouTube is another good one.
That's right.
Titan Defence LLP. So holla at your boy if you have any questions, and thank you very much for listening. Peace out, everyone.
Peace.
Thanks, guys.